It's my pleasure to welcome you all to this, and be quiet, Conor, for the moment, this lunchtime session on Ireland and the United Kingdom then and now. And I'm sure nobody needs to have Conor introduced, but I'll introduce him anyway. Conor was here at King's until 10 years ago.
More, actually.
An age ago. And sadly went off to the LSE. But I remember Conor when I came to King's, when he was interested in terrorism in a way that nobody else was. And I remember students laughing about the terrorism course. The joke would be, well, it's how to be a terrorist, because I think it must have been pretty much unique in its time. Anyway, Conor's going to talk for about 45 minutes, and then Natasha, who I'll introduce afterwards, will have a response of up to 15 minutes. There were to be 30 minutes for discussion. It's going to be shorter now because we'll finish at 2:30. So, Conor.
Thank you very much, Aileen. Good. So back to King's. So King's has got incredibly posh. King's, when I was here, was just a few buildings in King's Way, and it was kind of nice and intimate. There were various doors that could never open and so on, but didn't know how to get in. But now you've become very grand. And also, I have to tell everybody who's not here, King's is now the best law school in the country by objective governmental standards. And we at LSE are incredibly furious about this. Yeah, I think we lost by 0.1 or something. I will not explain to you, because I'm a fair person, what LSE says about this. I merely report our disgruntlement. The work that went into this paper is old work, so it may have been superseded. Natasha may be about to stand up and say, it's embarrassing. It's a work in progress. I'm recovering some stuff I did. And I thought, I was given the brief for this excellent idea for a conference from Cian, wherever he is hovering there. He asked me to talk about Ireland v UK with 40 years on. Is it 40 years on? It's 1976, yeah. And the European Court of Human Rights ruling was 78, and the European Commission was 76, so we can plausibly say 40 years on. And as a route in to discussion of the present, because your conference, I was here for a bit of the morning, and I'll be here for the last session this evening, was contemporary. But actually, I think there's an awful lot of contemporary stuff in what I'm going to say. It's about entering into a particular world which generated what we would now regard as torture, on which more perhaps later. And a glimpse at the pressures and tensions that generated this move to torture in a country which sees itself as a paragon and saw itself at the time as a paragon of the rule of law and accountability. And I think we can draw out through Natasha and in conversation the immediate resonances. So I lay you out in what I've got is about 40 minutes. So we have enough time for discussion, maybe even less. We'll see how it goes. The paper is there on some of these cloud things that Cian knows how to work. And you may want to dip into it later, you may not. It tells a story. And the story is about a certain period of time in Northern Ireland. And it starts, and I'm going to pick it up and refer to it as we go through this. It starts with the levels of political violence and state reaction to political violence that is the backdrop to the torture practices. And we need to know those to grasp quite how serious a situation it had become, within which it was possible to make decisions, as we now know, I think, decisions to engage in torture. Some of you may know, and Natasha may have something to say on this, under Rule 80 of the rules of the European Court of Human Rights, efforts are being made to reopen this case. And it's on the basis, inter alia, among other things, of the emergence of material facts, of which were unknown at the time. And one of these is alleged to be, I think there's no reason to doubt it, cabinet authorization for the practices of torture, which is a pretty big deal, and descriptions at the time of them as being torture, which is pretty remarkable from the United Kingdom's government. What were those times? Well, we all know the British troops were deployed in Northern Ireland summer of 1969. The violence was already getting worse in the period up to the fateful decision to introduce internment, on which more in a moment, in the summer of 1971, the catastrophic error had been made by the British authorities to deploy the forces of law from UK, but keep them under the control of the devolved administration in Northern Ireland. It would be like putting the federal troops under the control of the chief of police in Arkansas, Birmingham. It would be a bit like that. And it was not surprising that militarism reigned. There was a curfew imposed in July 1970. In the first 9 months of 1971, 30 people were killed, many more injured. In the first half of that year, the army conducted 30 people dead, the army conducted 346,385 vehicle searches, 1,234 searches of occupied buildings, and 5,793 searches of unoccupied premises. That is an amazingly invasive military presence in a very small place. When we bear in mind that almost certainly even by then it was targeted against a specific minority community, that is absolutely alienating. 346,000 plus vehicle searches. So already the army have moved in, been deployed. Already everyday life is completely pockmarked by the intrusive, invasive actions of the military. Gerry Fitt, a well-known MP, talking about the partisan conduct of the army, causing a great deal of hostility. The young Bernadette Devlin, given 6-month prison sentence for her part for her disturbances in the Bogside. So internment is the final card being played by the Stormont regime. That's the Northern Ireland devolved administration. Bears, by the way, for those of you coming to this fresh, no comparison with the agreed government of today. It was an homogeneously unionist, permanent government as a result of the abolition of proportional representation in the 1920s. There was a new Prime Minister, the previous one having been, as usual, brought down by Ian Paisley. And it's a terrific thing that the Nobel Prize was not accorded to Ian Paisley, as far as I know. He managed to die before he got it, so that there are at least some people who do not get it, and deservedly do not get it, as opposed to all the people who undeservedly get it. Brian Faulkner took over in March 1971. He'd been at Home Affairs during something which really tantalised the administration at the time, the IRA border campaign of 1957 to 1962. They believed that internment then had defeated the IRA, and they thought, let's try it again. It works. Let me through. I know what I'm doing, says Brian Faulkner. Significantly, I need to check with my, as it were, federal masters in London, and the government had no objection. And so the policy was put into place by Brian Faulkner, the Prime Minister, ludicrous when you say it like that, of Northern Ireland, and was able to order the army around. That's that catastrophic mismatch, which was the result of the 1969 deployment without the abolition of this government, in inverted commas. The trouble was, it may have worked in 1957, but you use the same list as you had in 1957, and you're going to be picking up quite a lot of old people, unless they're accidentally related to old people, in which case they count as young people. So the roundup was, well, let's quote Reginald Maudlin, famously attacked by Bernadette Devlin in the House of Commons, the man who said, as Home Secretary, leaving Northern Ireland, what a god-awful country, give me a scotch. He said, the experience of internment was almost by universal consent an unmitigated disaster that has left an indelible mark on the history of Northern Ireland. Just a guidance to the way the British authorities treat such matters. They always know that afterwards, they never know it at the time. The government completely defended internment and strongly supported it. And moreover, and this is a relevant point, it always had a legal basis. It always had a legal basis. It wasn't just something which they did as an act of brute force, which arguably the curfew had been. They operated under the emergency regulations from the Special Powers Act. Regulations are in the paper. Detention orders could be issued which were unlimited in duration, and then a separate order under another regulation led to the internment deployment of power, deployment of the internment power. This was the regime applied to 350 men who were taken in the initial army swoop on the 9th of August, and of these, 104 were released within 2 days, while the rest were made the subject of indefinite detention orders, overwhelmingly, of course, Catholic in religious complexion. The stats about violence are harrowing. Whereas the pre-internment months of 1971 had seen 30 politically related fatalities, the remainder of the year witnessed a further 143. 1972 was, as we all know, by common consent, the worst year of violence in the Troubles. Paul Wilkinson, one of the terrorism experts, a nice fellow, but definitely one of the experts, produced a whole theory about justifying internment around the levels of violence before internment having dropped off on the introduction of internment. As Brendan O'Leary memorably pointed out in the book review, he got the year of the introduction of internment wrong. He thought it was 1972, when in fact it had been 1971. The effect of which was that his theory was completely demolished. Now, Paul, who was nothing if not determined, didn't change that in any subsequent editions of the book that I remember. The law required an advisory committee, specially appointed by the Minister of Home Affairs, that's a Northern Ireland person, to consider representations. The Home Secretary, you see, there was this ambiguous relationship again, the federal dipping in to help the provincial, boasting that among the members accepting appointment is an Englishman, a former judge in the High Court of Kenya, Mr. P.N. Dalton, who is himself a Roman Catholic, said Reginald, rather proudly. You won't be surprised to know that this committee didn't do much. Its impact was minimal. Statements of evidence were made against internees that were anonymous. This was accepted, and these anonymous statements led to this committee advising that the person should be kept behind bars. In the first 3 months of its operation, only 16 of its recommendations led to releases. The British, when they are deploying state power like this, will usually camouflage it with some sort of legal veneer. This was a particularly shaky legal veneer. There's something in the paper about ways in which it was challenged in English law and some pretty scandalous judgments by English judges. I went on about this at some length in 1993 in an ill-tempered current legal problems lecture, which went on for an hour and a quarter, abusing English judges for how badly they'd behaved in regards to Northern Ireland, forgetting in the extent of my fury that I was being chaired by an English judge, Mr. Justice, as he then was, Stephen Sedley. But the contrast between English judges like Ackner, it's on page 4 of the paper, and individual judges in Northern Ireland who were direct targets of the IRA, including O'Donnell, who were ordering the release of people, trying to impose the rules of common law on reasons for arrest and so on, remained stark, actually, during the whole period. The English judges tended to perform strong legitimising roles in the exercise of state power in Northern Ireland in a way that was at least slightly more problematic so far as Northern Ireland judges were concerned. By February 1972, when the power had been in operation for 6 months, a total of 2,357 arrests had been made, 923 detention orders issued, 631 people formally interned. There were still 598 detainees interned under Regulation 11.2. So the policy was escalating through 1971 right into 1972. Then the contradiction in having a law and order policy administered by the Northern Irish sectarian, let's call it what it was, government in inverted commas, and the military who had to take instructions from them, with the British government looking on aghast sometimes at the impact on their public reputation, came to a head. The Northern Ireland government refused to accept the transfer of responsibility for law and order from Belfast to Whitehall, and Mr. Heath's government finally suspended Stormont. and introduced a period of direct rule from London, which carried on and on and on. But it did put the British government for the first time in the, as it were, firing line, taking direct responsibility for law and order. The emollient Mr. William Whitelaw was the new broom, greeted in Northern Ireland with a degree of enthusiasm because he wasn't the Unionist administration. And what then happened was they deepened the levels of judicial scrutiny. Now, in some ways, I'm not, Natasha will, I'm not going to draw too many comparisons with the present, but it's like a move from Bush to Obama. It's kind of much fresher. Mr. Whitelaw was he didn't look like Obama. Anybody remembers William Whitelaw? But he looked a bit like Tip O'Neill. Let's take an analogy. He looked a bit like Tip O'Neill after a heavy night's drinking. But he was an avuncular Tip O'Neill. He was Tip O'Neill after a few drinks before he got too drunk. And they introduced a new appellate system and the custody orders, and generally dressed it up with a detention appeal tribunal and legal representations a bit, safeguards and so on. These were all cases argued now by, remarkably, British counsel. English people came, lived in special premises and promulgated the state's case against the internees, and only the Northern Irish were only allowed to do the defence work, which is slightly, I think, colonial. It allowed the government the magic claim that internment as such is no more, which is what they said in the floor of the House. So be careful of rebranding. This was now called executive detention. I think that's what they called it. A minister enthused, the order does away with internment by order of the executive, he said, such a vote. So it's internment by order of the judicial branch. The executive is always keen to draw judges into shared responsibility for the exercise of executive power, and they're prepared to concede a little in order to gain the prize. And the prize is to be able to say, as that guy did, does away with internment by order of the executive, sotto voce, by order of the judiciary now. Another point, perhaps for today, the more rigorous procedures increased the number of people who were not being interned, if you know what I mean. Between February the 1st, 1973 and the 31st of October 1974, interim custody orders, which we had to learn to call them, were issued in respect of 725 individuals. Far from dying away, as was promised after the introduction of direct rule, internment continued in this new form to be an important part of security policy. And the final batch of detainees didn't get released until the end of 1975. The whole thing was overseen by a person, you'd really need to be a connoisseur of the English system to remember him. Sir Gordon Wilmot was enjoying his retirement at the age of 73, having been rather anonymous on grounds possibly of mediocrity, more likely on grounds of blandness. I'm gambling he's dead, because if he was 73 in 1973, I think the defamation is fairly secure, unless he's a Denning who was also litigious, as we remember, even at the age of 101. So I'm getting anxious about Sir Henry Gordon Wilmot. He came out of retirement at 73. You can just imagine the phone call. Now look at her, Wilmot. We need a chap to manage the Irish. Jolly good, I'm your man. And then Lady Wilmot saying, where are you going? I'll be back at tea. I could just imagine her. And of course, the paradoxical effect of all these liberal reforms with Sir Gordon or Sir Henry John Gordon or Sir Henry Gordon brought in was that internment increased. The New Law Journal thought the thing was an improvement. You know, contemporary critique is it's an improvement, whereas in fact all it's done is camouflage the aggressive state power more effectively. And that takes us to interrogation in depth, as it was called. And I think it's important to see it against the background of this extensive exercise of state power involving many, many, many hundreds of people, almost all of them Catholic nationalists, and many, many, many of them having no connection with any violence before they are detained. But we can't speak with certainty about how they responded to being detained, like the 350,000 cars that were stopped and searched and so on and so forth. Almost immediately following the introduction of internment in August 1971, there had been allegations began to surface of severe ill treatment and brutality towards internees. The Irish were beginning to learn about it for sure, even as early as that, happened very quickly, August, September 1971. And the government moved reasonably early to appoint the Ombudsman, Parliamentary Commissioner Sir Edmund Compton. Introduced this. Now, the government is the UK government. Back to this problem. The Northern Ireland government, as it then was, is issuing the orders, and the British government is tidying up afterwards. Ridiculous, ridiculous. And the 31st of August, the government here appointed Sir Edmund Compton. The Prime Minister of the day was Edward Heath, a man whose independence was brought home to the House of Commons by the Prime Minister's assurance his capacity was that of a judge. I think that's quite important. He had His Honour Edgar S. Fay, QC, and Dr. Ronald Gibson. The search for judicial camouflage is not only in the courtroom, it's also in the committee room, the inquiry room. And what Edward Heath is saying, he's almost a judge, folks. He's an ombuds. How do you finish that? Is that a Scandinavian word? He's sort of judgy. And that's supposed to communicate something. Well, what it communicated was everything's fine. But what Compton revealed in declaring everything to be fine was quite how extraordinarily disturbing what being fine was. Because, as is often the case, you don't really believe the stories because you can't believe them until you find they're true. And these were stories confirmed by this official investigation. What was fine were the famous 5 techniques of sensory deprivation: wall standing, hooding, subjection to noise, deprivation of sleep, deprivation of food and drink, etc. The CIA abuse seems to have been at an extraordinary level, but there is certainly a lot of resemblances here between what was routinely done there and here. And now, and the colonial point wasn't entirely facetious. The government defends the techniques, pointing out they've been used many times in situations of post-war colonial agitation. Palestine, this is the government, this is not agitators or NCCL or Angela's Justice Bunch. This is the government. Palestine, we did this in Palestine, we did it in Malaya, we did it in Kenya, we did it in Cyprus, we did it in, and did we know we had them? The British Cameroons. We did them in Brunei before we handed over to that nice man, the Sultan. We did them in British Guyana, we did them in Aden, we did them in Borneo, we did them in Malaysia, we did it in the Persian Gulf. This is practically, we're doing it everywhere. And that was, Compton's response was, these techniques of sensory deprivation are physical ill-treatment, they don't amount to physical brutality. We consider that, and this is the quote, brutality is an inhuman or savage form of cruelty, and the cruelty implies the disposition to inflict suffering coupled with indifference to or pleasure in the victim's pain. We do not think that's what happened. In other words, it was organised, institutionalised, and like the priest who beat you up at school, he took no pleasure from it, and that was therefore okay. That's the Sir Edmund Compton report. The Home Secretary was able, of course, to boast that the committee had found no evidence of physical brutality, still less of torture, and he was able to say he could think of no country in the world where such a standard of thoroughness and impartiality could have been maintained. This is all against a background of having admitted the deployment of these techniques. So it's not that they're saying they didn't happen, we're marvellous. They're saying they happened, but we're really good at it. We all went to ill-treatment school, and we know it's not torture, and we know it's not even cruelty, and it's fine. And that was at the time. You know, it's easy for Reggie Maudling to write in some biography later on. It's a disaster. At the time, they thought it was marvellous, which may be why Bernadette Devlin attacked him in Parliament in a memorable moment. But Compton events drove it further. The newspapers, the Sunday Times, then a proper newspaper, was breaking stories about this, and there had to be another inquiry. The Home Secretary announced it in his introduction to Compton, so something told them Compton wasn't enough. Sometimes your committees can go too far to support you. You may remember one in the aftermath of the death of Kelly. The Blair administration invited a judge from Northern Ireland to make an inquiry, which he, over 5 volumes, said nothing, absolutely nothing went wrong at all, and if I may say so, the government are marvellous. And he sort of overdid it. And Compton had slightly overdone it, so they needed to have another one. And they got Lord Parker of Waddington. He was, compared to Henry, practically a juvenile. He was only 71. He had nothing to do, having just retired after 13 years as Lord Chief Justice. And they needed a bit of credibility, so they put on Lord Gardiner, one of the very few judicial heroes, a very, very honourable man, who had served as Lord Chancellor in the Wilson administration in the 1960s. I learned this just 2 days ago, having agreed to serve only on condition that he could introduce a member's bill to abolish the death sentence. He wouldn't do it, the job, unless he had a chance to abolish the death sentence, and he abolished the death sentence. Fantastic. What an achievement. More or less all of it. He was on. We knew probably which way this guy would go. So who's the third guy? Well, I unearthed it, he said, like a detective. So I imagine it's been so long since I did this, everybody's unearthed it, which is a bit embarrassing. But I went to the biography of J.A. Boyd Carpenter. Yes, J.A. Boyd Carpenter, even more obscure than the various obscure people other than Gardiner whom I've referred to. He was a Conservative MP for Kingston upon Thames. He'd held the seat since 1945. This man was also no juvenile. They go for maturity in a Chinese kind of way in the 1970s. He'd been in various minor and forgettable parts of various forgettable and minor Tory administrations. This is the bit that's interesting. In his autobiography, Boyd Carpenter never mentions, not once in his autobiography, this man had the dullest life in politics, and he never mentions the one thing, he was on the Parker Committee. Isn't that amazing? He never mentions it. He does say this. He says, in the latter part of 1971, he dictates to his secretary, writes, the Prime Minister, Edward Heath, who had sent for me in connection with another matter, offered me chairmanship of the Civil Aviation Authority, an appointment which would, quote, however, not be announced for some time. So I'm guessing he may be dead. I hope he's dead. It must be dead. I'm just imagining Edward Heath said, look, we've got this terrible thing. Bloody natives arrest us a bit in Northern Ireland. We've got Parker, he's a marvellous fellow. We've got this lefty fellow, can't remember his name now, Lord Chancellor type. We need a dependable pair of whatever you are. And you're so good, we're going to make you chair of the aeroplanes. Oh, marvellous. But we're not going to make you chair of airplanes for 6 months. So what happens is the report comes out. Parker says, I'll get to what Parker says, with little Boyd Waddington beside him. And he's made chair of the Civil Aviation Authority later, and he's made Lord Boyd Carpenter of Crookseston. So that's the way the British system works, by the way. That's the way it works. And that still works like that. It still works like that. They don't even have to make them lords. Their desire to be lords means they're putty in your hands. This is what the majority report Parker said. The majority considered that while long-term mental injury cannot be scientifically ruled out as a result of these methods, particularly in the case of constitutionally vulnerable injury, there is no real risk of such injury if proper safeguards are applied in the operation of these techniques. We're in the world of the TV star Alan Dershowitz. We're in the world of kind of organising torture, you know. So what we do is, if you have the right techniques, it'll be fine. The majority said, this is as bad as me, no footnotes, there is no doubt that the information obtained by these operations directly and indirectly was responsible for the saving of lives of innocent citizens. They said that, just said it. Then they went into it. This is amazing, they said. It's an outstanding success, this torture bit. I'm sorry, whatever it is. As a direct result of it, following information. And then they were reading like from a press release from the military. Identification of 700 members of both IRA factions. 40 sheets giving details of the organisation and structure of the IRA units. These people who are being subjected to ill treatment, they're just hard to believe they could fit it into their busy day, writing all the information that they had about the IRA. Sorry if they're listening, but you know what I mean. Details of possible IRA operations, details of morale, operational directives, propaganda techniques, the discovery of individual responsibility for incidents recorded in police files previously unexplained. They fell for this whole thing. They all agreed it. They all agreed it. They reported all this as matters of fact, and this is what they said, which should have haunted them to their graves if they both died. There is no reason to rule out these techniques on moral grounds. That's pretty bloody unnecessary, on moral grounds. And that it was possible to operate them in a manner consistent with the highest standards of our society. From the start, it's, we do this stuff well. We can do it better, but we do it well. We take no pleasure in it. We're organised. and that is the defence. We're familiar with it from more recent events. Fortunately, their report was destroyed at its arrival by the dissent, Lord Gardner. They didn't really plan for remarks like this. The blame for this sorry story, if blame there be, must lie with those who many years ago decided that in emergency conditions, in colonial-type situations, we should abandon our legal, well-tried and highly successful wartime interrogation methods and replace them by procedures which were secret, illegal, not morally justifiable and alien to the traditions of what I still believe to be the greatest democracy in the world. Well, there's no contradicting that. He's got it. It was a anti-colonial, it was a colonial practice which had grown, as they boasted to Compton, through their efforts to retain their empire, and had been driven by a racist distaste for and dislike of the individuals who were being made subject to it. It wasn't those decent Germans, say what you like about them, but they know their Beethoven. It was funny fellows from different countries whom we can torture if we wish. And it's a fantastic thing that in Kenya, some of these people have been putting the country back on the spotlight in court cases to their shock, horror and fear. Nevertheless, this spread into Northern Ireland, colonial type situation. I am convinced they didn't really notice that Northern Ireland was part of the United Kingdom. And they sort of thought about these Catholic people as practically natives. And they were white, which is kind of accident, but they were nevertheless to be treated like people who weren't white. And I think they were caught out because they forgot, and they forgot that there was a difference. And Gardner, colonial type situation, got it. Now, the report was published on the 2nd of March 1972. The government had had it for months. The New Law Journal described many of Parker's and Boyd Carpenter's, we have to add him, though I wonder whether he ever read it, report as staggering in its implications. Though it disclaims any allegiance to the principle that the end justifies the means, it is only in terms of that principle that the majority's conclusions make any sense at all. Its claim that it wasn't immoral really came back, as I say, to haunt it. The Prime Minister declined to take the majority opinion as even a qualified endorsement of sensory deprivation. While welcoming the report in Parliament, Edward Heath announced that the techniques which the committee examined will not be used in future as an aid to interrogation. So the committee's sanction was disowned by the government. Memories of the way in which the government would not seek to keep Irish prisoners in jail when the evidence that they had been not guilty of the crimes for which they had been convicted was overwhelming, because they would not risk the judges retaining them in prison in order to maintain the illusion of judicial impartiality. The Birmingham case, the Guildford cases, the Maguire cases, this case, that case, the other case. You may remember towards the end of that, the government would show up and Lord Lane would be peering at them and they'd say no evidence. And Lord whoever it was would say, no, let me at them, I'll keep them in jail. Sometimes the judges go too far in their enthusiasm. The Nationalist MP, Frank McManus, intervened to accuse the authors of the majority report of having attempted to whitewash what went on. The government, he said, had acted only because it had been shamed by force of public opinion into discontinuing barbaric practices. They hadn't been shamed by public opinion. They certainly hadn't been shamed by Parker. They had been mildly shamed by Gardner. What really made the difference, concluding set of remarks, was that in December 1971, the Irish government had lodged an application with the European Commission of Human Rights complaining that the alleged ill treatment of internees in Northern Ireland was in breach of the United Kingdom's obligation under the European Convention on Human Rights. It was getting international and it was getting serious. So March, they stop it. Now we all know, you may remember, they lost the memo. That's hence my made-up quote at the start. Those who want to repeat the past need first willfully to forget it. Somebody pointed out the British authorities had banned this kind of behaviour when it became apparent they were doing it again in southern Iraq. And I believe the government actually said, oh, we lost that file, or we couldn't find it, or it was mislaid or something. unbelievable. It was the fear of litigation. Much of the rest of the 1970s was occupied by this case. To Ireland's enormous credit, they never budged. They carried it on. Heath, Wilson, Callaghan, Heath and Wilson begging them, Callaghan, to stop it. It was a running sword in international relations. The 2nd of March statement had been designed to end proceedings, you see, by saying, look, it's over. Now, this is relevant to what the brave people trying to relaunch this case are saying. The European Commission found that its investigation of the case had been hampered by the respondent government, which did not always afford it the assistance desirable. The European Court agreed, explicitly stating it regretted this attitude on the part of the government. The Commission said neither the witnesses from the security forces nor the case witnesses put forward by the applicant government have given accurate and complete accounts of what had happened. So there was absolute contemporaneous awareness that they were being misled by the British government. And the British government was hostile to this whole internationalisation and was trying to buy off the Irish and minimise the impact. The European Court of Human Rights overturned, without needing to, the finding of torture by the European Commission, which was the finding 40 years ago this year. They agreed by 16 votes to 1, that the 5 techniques were amounted to inhuman treatment within the meaning of Article 3. You will not be surprised, those of you who follow the court's early history, that the sole dissentient was Fitzmaurice, celebrated by John Finnis in a recent, very popular and well-received lecture, who says Fitzmaurice was a marvellous judge. Fitzmaurice is emblematic of where many leading judges and political figures in this country want to take us. Back to a person who's able to say, if commendable zeal for the observance and implementation of the Convention is allowed to drive out common sense, the whole system will end by becoming discredited. I think probably Fitzmaurice influenced them to water down the torture verdict, and it came in as inhuman treatment. I've looked at all the papers that contemporaneously reported it. The 1978 European Court decision was regarded as a triumph for the British government because it confirmed what the Times said: torture was never the right word. The New Law Journal said, at least it was worth doing. Sam Silken says, highly satisfactory. He was the Attorney General. Highly satisfactory. The men concerned, some of whom, as I say, may or may not be watching from their homes, received some small pecuniary compensation via the common law. In a literary magazine, Granta, the writer John Conroy described what happened to them. I'll end on that, some of them at least. There's been developments, I'd say. One of them, Sean McKenna, after treatment for acute anxiety, died in 1975 of a heart attack, age 45. Pat Shivers suffered similar anxiety attacks until his death from stomach cancer in 1985 at the age of 54. Michael Montgomery's marriage ended in 1977, and he died of a heart attack in 1984, age 49. Liam Shannon developed chronic diarrhea after his interrogation, and in 1975 was diagnosed as having Crohn's disease. And in 1974, Jared McCurr was found to have cancer of the lymph glands. These were the experiments in interrogation which Compton told us yielded so much information. It's a terrible story. It's over to Natasha, I think, to give us a bit of a contemporary ring and to critique and tell me about all the books I haven't checked. Thank you very much.
Now, as Conor says, we'll hear from Natasha Simonsen, who is a fellow at King's and is just tying up her DPhil in order to commence life at the bar in September.
Thank you, Aileen, and thank you, Conor. I can't help but begin with just my favourite Judge Fitzmaurice anecdote, which is also from his dissenting judgment in the Ireland and the United Kingdom case. So he disagrees with everybody else and says these techniques aren't even inhuman and degrading, let alone torture. And then he says those words are designed to capture treatment of a wholly different order of suffering to what these men are complaining of. The kind of thing that the drafters of the convention had in mind when they drafted Article 3 was the kind of atrocity that would be involved in being forced to desecrate a picture of one's head of state. So, you sort of get a bit of an idea of where he's coming from with respect to the British government. He then also has a nice footnote where he says, he speculates whether or not Christ was really degraded by being forced to carry his own cross. Truly, truly bizarre. Okay, let's come back to some of the important themes that Conor's analysis has highlighted. And these themes include the precariousness of civil liberties in the context of counter-terrorism, and the tensions between secrecy and accountability when national security is at stake or allegedly at stake. And Conor's paper has also highlighted some of the challenges that are faced in post-conflict societies in particular, where the society is characterised by pervasive distrust of institutions, and questions about how we might move from that situation of pervasive distrust to a situation in which people might begin to be able to feel that some justice has been done. And we've also heard importantly about the role of law in all of this, from its virtual suspension to its use to provide a thin veneer over executive action, to its blatant violation. And these themes, of course, are eerily familiar to us all. In my brief remarks, I will pick up where Conor left off by discussing the proceedings that are currently pending before the Strasbourg court on behalf of the hooded men whose ill treatment is at the heart of this case. I will then consider the options that are open to the European Court of Human Rights should it decide to revisit that controversial judgment, and I'll conclude with some reflections on what I think this story can tell us about accountability for torture in the counter-terrorism context then and now. So, as many of you will be aware, in June 2014, Radio Telefesh Aren aired a documentary in which new evidence about the hooded men was uncovered from the British National Archives at Kew. And lawyers for the surviving hooded men have immediately wrote after the documentary was aired to the Irish Attorney General, asking him to apply to the European Court to reopen that 1978 judgment. A prompt refusal from the Attorney General led to an equally prompt application for judicial review. Now, the Strasbourg court allows an application for revision of a judgment to be lodged within 6 months after the discovery of a new fact. So the Irish government stalled for almost the full 6 months, and then 2 days before the expiry of that window, finally backed down. And we have no news as yet on whether the court will agree to reopen its 1978 finding, but we could speculate, perhaps, that they may be deliberately avoiding what is no doubt a political hot potato at a time when relations between London and Strasbourg are not exactly great. Separate proceedings are also on foot in the Belfast High Court. We might hear more in discussion from Sarah about those. And those domestic proceedings are seeking an investigation into, I gather, who ordered and who authorised the 5 techniques, among other things. After several delays at the request of the British government, I'm told the hearing is likely to occur later this year. But in the meantime, one of the hooded men has died, and another has accused the government of delaying the proceedings deliberately in the hope that if enough time passes, more will follow suit. My comments here are primarily addressed to the Strasbourg proceedings. And Conor and I agree that of the various judicial, quasi-judicial and executive studies on the use of these 5 techniques in interrogation, the European Commission on Human Rights was the only body that got it right. The 5 techniques were torture. They were torture in 1978, even when the European Court refused to name it, and they would be torture if they were used today, as of course they still are. So how did the court get it so wrong, and what can we do about it now? On this first question, how did they get it wrong? Well, as we've heard from Conor, perhaps the only real explanation might be political. But to the extent that a legal justification was proffered, this was it. The 1978 judgment defined torture as, quote, deliberate inhuman treatment causing very serious and cruel suffering. Now, if we look at that definition, there was never any question that the 5 techniques were applied deliberately. And the court had also already accepted that they were inhuman. So on the court's own definition of torture, the only possible basis for declining to find it was that the suffering the hooded men experienced was insufficiently severe. Now, in view of what we know those men went through, that finding is perverse. But Ireland now alleges that one of the United Kingdom's expert witnesses deliberately misled the European Commission of Human Rights and the Strasbourg Court, as Conor has told us. And one of the documents uncovered in the National Archives was a report from a key British witness which directly contradicts the evidence he gave at Strasbourg, which went directly to this issue of the severity of the suffering of the hooded men. So this might go some way towards helping to explain how Strasbourg got it so badly wrong. As for what they can do about it now, the court rules specify that the parties may apply for revision of a judgment where the new evidence satisfies 2 criteria. First, it must be such that it, quote, might by its nature have a decisive influence. And second, it must have been unknown to the court and to the parties at the time of the original hearing. Unknown and also could not reasonably have been known to the parties at the time of that original hearing. So beyond that, beyond those 2 criteria, it's all at the court's discretion. So if the criteria are met, then a chamber of the court may decide of its own motion to refuse, or it can communicate the matter to the parties for the receipt of written evidence and/or a hearing. Again, at the discretion of the court. So if the severity of suffering was, as it appears to be from the judgment, the sole reason, at least on the papers, for withholding the label torture, then it seems to me that this new evidence must surely be decisive. Whether it could reasonably have been known to Ireland at the time of the original proceedings is no doubt a matter for some debate, but if Ireland is right, and if the parties were deliberately misled, then surely this application must be accepted. So in that case, there are 2 options open to the Strasbourg Court, depending on whether it applies the standards of 1978 or the standards of 2016. The first is to find that it wasn't torture then, but it would be torture now. The second is to find that it was torture then, and it would be torture now. So I'll deal with each in turn. So option 1, the court could conceivably stand by its 1978 judgment and hold that the same, but nevertheless hold that the same techniques, if they were inflicted today, would, by today's standards, constitute torture. So they were inhuman and degrading then, but if happened today, they would be torture. What this would essentially boil down to is, well, it wasn't torture then, but it would be torture now. And most commentators who have looked at this case, and there's not too many since the recent documentary, but most commentators have assumed that this is the route that the court will follow, applying the contemporary understanding of torture to the new evidence of what happened in the 1970s. This conclusion relies on what the court describes as an evolutive approach. Sorry, which face is that? That's the 5-minute face. Okay, thanks. So this conclusion would rely on the evolutive approach to interpreting the European Convention, and in particular on the 1996 case of Salmouni in France, in which the European Court said that, quote, the increasingly high standards being required in the area of the protection of human rights correspondingly and inevitably requires greater firmness in assessing breaches. As a result, the court expressly stated in Salmouni that certain acts which were classified in the past as inhuman and degrading treatment might, in the future, be classified as torture. But for a newly convened chamber of the European Court to hold that these techniques were inhuman and degrading then, but would be torture now, is in my view, an abdication, not to say a disgrace. It would be a hollow victory for Ireland and a hollow victory for the hooded men, while seeming to make the statement that these interrogation techniques are not permissible now. It would also allow the court to avoid engaging with the vexed question of its approach to its own precedent. But perhaps more importantly for this politically savvy institution, it might avoid the court further antagonising a hostile British public. There are many difficulties with this approach, and I'll just highlight two. The first is that it's by no means clear that contemporary rather than historical standards should apply. The court rules weren't drafted with reopening of decades-old cases in mind, and there haven't been any other revisions involving an equivalent delay. Moreover, in domestic proceedings on historical matters, whether civil or criminal, the law that the courts will apply is ordinarily the law of the time that the incident happened. In another context, the inimitable Lord Denning put it succinctly, we must not look at this 1947 accident with 1954 spectacles. So I think it's far from self-evident that we should assess the events of the 1970s through 2016 spectacles. But the second difficulty is that I don't think it's clear that the Strasbourg Court's jurisprudence on the meaning of torture has, in fact, changed over time. Salmouni itself concerned a beating that was so brutal that it would certainly have met the high threshold set in Ireland and the United Kingdom. And long after Salmouni, the court continues to insist on a very high threshold for ill treatment to be qualified as torture. I found very little evidence at all of a more expansive understanding of torture in the court's jurisprudence. And I've analysed statistics of the Strasbourg Court over a 9-year period between 2007 and 2015, and they find just a handful of cases of torture each year. So the figures don't suggest there's been a greater firmness in assessing breaches, at least in respect of torture. The statistics won't tell us the whole story, but the case law doesn't support that either. And in cases where the very few cases where the court has found torture include Aydin, where there was a brutal rape, Ilascu and Moldova, where there were mock executions, among other things, Virabayan and Armenia, where there was beating of the genitals with a metal rod. And if we contrast this with a recent case where torture wasn't found to have been established in Mahmut Kaya, the victim's body in that case was found with marks from wire-bound wrists and prolonged exposure of the feet to water and snow. The court concluded that was inhuman and degrading, but there wasn't enough evidence of how severe the suffering was to call it torture. So while I'm certain that the suffering of the hooded men was torture then and it is torture now, my purpose is just to show that in arguing for a 2016 rather than a 1978 approach to torture, I'm not sure that's going to take us very far. Quite simply, there isn't any support for the contention that Strasbourg's interpretation of torture has evolved over time. So if I'm right on that, then it was inhuman and degrading then, but it would be torture now approach isn't really open to the Strasbourg Court at all. And this brings me to the second option, which is to find that the court was wrong in 1978, that the 5 techniques constituted torture, and that if they were to be repeated today, as we know they are torture now as well. Now, oh, angry face, okay, crash tackle coming. Conor's paper has showed that the evidence before the court in 1978 was very strong. The European Commission's finding was comprehensive. It stretched to more than 500 pages. The Commission heard 10 days of oral evidence, and the transcript of those proceedings is more than 10,000 pages long. So the evidence before the European Commission was that this was torture. And the European Court interfered with that finding, though it wasn't asked to do so, and it wasn't even contested by Britain. Whether Britain will contest it in the reopened proceedings, should we get that far, will be interesting to see. The Strasbourg Court finally has the chance to correct the record, and we must hope that it does. The litigation in this case has had implications far beyond Ireland and the United Kingdom. The 78 judgment influenced the drafting of the UN Convention Against Torture, and it features in the case law of courts and the work of treaty bodies the world over. So I'm fond of saying that torture being torture matters. It's a unique moral wrong, together perhaps only with slavery, the quintessential violation of human dignity. So a revision of this judgment on this unique moral wrong could have the most profound implications. But it's not for those implications that I urge the court to correct the record, because the suffering of the hooded men goes on. That many of them have gone to early graves should not be forgotten, and nor should it be used to consign this case to history. For these men, as for many in Northern Ireland, the past is an experience that they live every day. That experience was torture, and the court should say so.
Now we have 20 minutes for comments and questions from the floor. Can I see some hands? Got one, two. If I take three, 1, 2. Did you get a hand up? Okay, 1 and 2 then. Can you introduce yourself before you ask your question, make a comment?
What's the implication of the hiding of the evidence in the human rights terms? Is there something additional that can be brought to the court about the burying of evidence?
I mean, it could well be that there's an additional Article 13 violation of the right to an effective remedy. As Conor said, the court was quite open in the 78 judgment, and in the 1976 judgment there are also criticisms of the respondent state's conduct before the tribunal. The lawyer for the hooded men very kindly sent me a copy last night of the application that they've made under Rule 80 to Strasbourg, but I haven't had the time yet to go into it in full. But my hunch is that if they do accept to reopen the judgment, there will be a full hearing on the matter, and it could well be argued that there's an additional violation of Article 13 in that the men were also then denied an effective remedy by reason of the United Kingdom's conduct.
I mean, you have got the potential for a tricky known unknown, and they use the European Court's own frank appraisal of itself as having been denied the full information to say that it's not a new fact, it's not impossible, they'll run for it. Article 13 is the best bet, I think, but I haven't seen the papers at all.
Fall back on the investigative obligation arising from the trust right.
So I'm aware that the Belfast judicial review proceedings are in part alleging failures to conduct effective investigations under Articles 3 and Articles 2 because of some of the deaths that have occurred following the treatment. As far as I'm aware, it's not engaged, at least at this stage, in Strasbourg, but it would be interesting to see. It would be very interesting to discuss.
Thank you.
Thank you very much for these excellent papers. My name is Natasha Simonsen, and I'm from Queen's University Belfast, and I'm very interested in this case and the subject. So I'd like to probe, I suppose, the relationship between the procedural element to reopening the case and the substantive potential findings. In terms of the gateway through Rule 80 and the need for some new relative evidence, what I want to flag up is the potential for going down perhaps a positive route and a potential for going down potentially a negative route in that regard in terms of the substantive understanding of torture, and I would like your views on that. I suppose one potentially negative route for me is actually an emphasis on long-term consequences for these people and the effects that the ill-treatment had, because that really takes us back to this emphasis on intensity of suffering as being essential to the wrong of torture inflicted, and it allows for some potential for moral luck in a sense of actually instances where somebody just happened to be more robust to sustain very severe ill treatment without long-term consequences. What I'm wondering then is whether we should be emphasizing the wrong of torture more than the harm of torture in substantively pinning down what took place, and whether the evidence that should really be prioritized then is the very knowledge and intent of those who perpetrated, who authorized the 5 techniques in this new evidence. Because that would tie it more to really the wrongdoing that we're trying to capture, which isn't purely about the harm that I totally acknowledge was incredibly significant, but rather the wrongdoing inflicted on our love.
I would love to see more of a focus on the wrong of torture. I think the Strasbourg court has sort of just, I think Jeremy Waldron said it's almost a list-based approach that the Strasbourg court adopts, where they say, oh, well, this Falanga has been held to be torture. So, now when we see Falanga, we just apply we check it off the list, we say that's torture now. There's very little substantive engagement in the court's reasoning with what it is that makes torture and what it is that makes torture wrong. And for my part, I think that the emphasis on the harm is completely misplaced. I think that the long-term consequences sort of stuff is a recipe for disaster to go down that road, and I would love to see more focus on the wrong.
If I were an advocate before the European Court of Human Rights, I would start, as I ended, by picking up and showing the victims. So we need to locate this in an adversarial process where the tangibility of the harm in these cases is a strong part of the advocate's armoury, just as would, were it the case, which it isn't, the healthy post-interrogation lives of these people have been an argument, irrational though it would be, in the hands of the government. So I think the process of establishing truth drives you, given you have individuals who represent the wrong in the direction of personal harm. Difficult to resist that.
I would also add, if I could, that I think that where you have treatment that might be on the borderline, the harm can be more important. So if you could have ill treatment that's quite severe, but on a particularly vulnerable person is even more severe. And in those cases, I think the practical benefit of having concrete evidence of harm is that it might help you to show that that torture threshold has been crossed.
Since we're swapping Fitzmaurice stories, he did explain corporal punishment was fine because he got beaten up at school and it did him no harm, which is a sophisticated position, isn't the denial of the harm element.
But maybe that's where he went so badly wrong.
That's right, exactly. I think he revealed more than he expected.
There was a question 4 rows back, and then I'll take you. So, yes.
Yeah, hi, Davina from Ellen. I'm really interested in the role of time in your analysis, and so harm and wrong, and kind of the bloodline of torture, taking it back to the colonial era, and how that was then justified because it was the case then. I wonder if the mature case, about Mau insurgency, I think Kelly to an extent, but another discovery of documents has occurred in that context, where we've now got a capacity, I suppose, to have a judicial inquiry into torture. I just wonder if you could speak a bit about the role of time and how far back that statute of limitation should go, the impact on the definition, and whether actually a judicial finding in those cases of colonial torture and to stem and stop that bloodline of torture.
I think the first, because it was quite interesting when, Davika, when the Human Rights Act was first introduced very early on, I think it was Wilson case, they had a very lively discussion about whether Charles I could, through descendants, deploy a sort of due process argument about being executed. And I welcome, actually, the way in which good advocates can destabilise assumptions about the past in the way that, for example, in that case was done. But I also hope that it doesn't become just about the past, because I find a bit disturbing the willingness of leaders to apologise for the conduct of other people while carrying on exactly the same way at the present. So I see these cases destabilising in that double sense. They're subverting assumptions about the past and forcing the apologies that should come, but also they're reminding us, which is why I did the paper the way I did it, of the fragility of contemporary judgments about our own morality. If the British if the British are ordered by the Americans next year with the new president to enter a foreign country to kill people for the Americans, which is what usually the British do since they lost their empire, we will be back in this, and pretty quick, if the American president is somebody who believes in torture. So I'm just hoping that the destabilisation based on the past has a contemporary destabilisation too.
I just wanted to add one thing, which is that I think there's an important connection between sort of the historical judicial cases and the uncovering of the documentary evidence, and that ties into some work that I know is coming in Leora's book when it comes out, that Leora and others have looked into in terms of the obligation, whether there might be an obligation on the state to keep records. And even if records are kept secret, perhaps there should be, that secrecy assessment should be subject to a proportionality analysis, so that the longer you keep the record secret, the stronger the justification needs to be for not releasing them into the public domain. And I think that this question about the relationship between time and sort of remedies of human rights violations is integrally connected to that question about what we do with records and who decides when their secret is kept and for how long. We talked a little in the earlier session this morning about the role that a finding of violation has as a remedy in and of itself, even apart from any damages. And I think that symbolic statement that this is torture, whether in Mau Mau or in the Hooded Men case, is so important for the victims, but also then because we've seen the sort of abuse and misuse of language that lawyers will put those symbolic findings or the absence of a symbolic finding to effect in the US torture memoranda and in other contexts.
Gentleman at the front, and then I'll take you afterwards.
Thank you for the excellent presentations. Just two brief questions. One, in terms of thinking about the focus on the severity of the treatment of the strategies of the advocates, is there also concern about opening up going into areas where it becomes difficult to adjudicate because of passage of time and the memories, depending on what the focus of the inquiry is on, because of what's going to be limited and what it can look at. And I guess the other question was, how extensive is the court's jurisprudence on the Rule 80? I mean, is there, in terms of, in other words, much you could say? Are there countervailing concerns about finality that are invoked? I don't know how common Rule 80 is invoked in that context.
So what's your name?
Oh, John.
John, sorry, John. I think as regards the first one, it's not like what's going on in Germany at the moment, where you have criminal proceedings against an individual and it's very old and you have these people and so the whole issue turns on credibility. The nice thing about the European proceedings, in my opinion, I'll be interested in what said here, Natasha, is that it is a structural thing we're investigating. So memory is not the vital dimension to this. It's revelations in documents, it's proceedings. If it's true that Lord Carrington did agree to torture and so on, we don't need, because we have the papers, some old guy to turn up who says he remembers Lord Carrington saying it. So I think we're okay on that one in the particular nature of these proceedings, and it shouldn't hold us back, though I take your point that it can do in certain types of proceedings.
And just to answer then the Rule 80 question, there is some jurisprudence on it. In fact, I was surprised when I was doing the search to see just how many cases there are where the European Court has been approached to revise a judgment. I will look into it in more depth if I sort of make something of the paper, but from the glance that I did in preparation for today, it seems to me that most of those revisions are relatively minor. So they will involve something like, the quantification of damages, or in one case there was, one of the parties was misnamed. And so, that's been the kind of jurisprudence. The other issue on which there is more jurisprudence under Rule 80 is whether the new evidence was decisive or not. And so there's quite a lot of debate, which I think is not relevant here strictly. Of course, the court will assess decisiveness, but I think I mean, if it's true that the chief medical witness for the United Kingdom lied and is, you know, on paper elsewhere saying exactly the opposite of what he said before the court, then I think surely that must be decisive.
Thank you. No, sir. Back here.
So this is more a comment than a question, I think, but I'm struck by...
Can I ask you to identify yourself?
Oh, yeah, I'm David Cole. So I'm struck by the way in which these efforts, this effort of accountability sort of allows the court itself to displace responsibility. So if it succeeds on the ground that the reason we said it was not fortunate was because we were misled by the courts. And it reminds me of two U.S. sort of, parallels. One is after Korematsu, which I talked about this morning, the Supreme Court upheld the internment of the Japanese on the ground that, well, you know, they're an inscrutable lot, and we can't tell which ones are bad and which ones are good, and so we just have to lock them all up. And then they discovered evidence years later that there was some contrary findings by the FBI that there had not been any acts of espionage or sabotage by the Japanese community, which had been originally put in a footnote to the Supreme Court brief, but then dropped out in the final brief of the Supreme Court. And the conviction of Korematsu was actually reversed on the ground that the prosecutors had misled the court by not giving that kind of evidence. And the same thing with the Senate Select Committee on Intelligence, which recently issued a report about the CIA torture program, a very damning report. But of course, the Senate Select Committee on Intelligence had been informed about the torture early on and had okayed it, just as the Supreme Court was informed about the internment and had okayed it. And in their more recent report, they essentially charged the CIA with lying to them about various aspects of the torture program. And therefore, now we know the torture program is wrong. So in both of those instances, the accountability body was actually in some sense implicated by saying it was okay initially, and then was able to kind of get itself off the hook by pointing to the wrongdoing elsewhere. And it seems like that's the sort of same strategy here. I guess you have to use that strategy, because how else do you reopen something? But it raises questions.
Yeah, it's like, sorry, just quickly, but it's like the king can do no wrong, but the king was misinformed, so.
Yeah, I mean, I agree. I think this is really just a window. You know, there are no other grounds, at least in the rules of the Strasbourg Court, on which a judgment can be revised, other than those in Rule 80 that I mentioned. So this is a gateway to get it open. But what I would equally love to see is this finding challenged in other cases. It won't help the hooded men, but were the court to find in, say, if the court had found in al-Nashiri or in Abu Zubayr, in the al-Husseini cases that were talked about by Federico this morning, if the court had said, you know what, we got Ireland wrong, and torture is in fact, you know, infliction of severe suffering combined with a purpose, the test we applied in Ireland was wrong. Now, Alistair Mowbray has a very good piece, I think one of not much literature in this particular area, about the Strasbourg Court's approach to its own precedent and how reluctant they are to come out and say, we're now departing from something that we said before. And partly I wonder if it's the nature of this sort of supranational court and then the mix of civil and common law jurisprudence. They just don't have an established approach to precedent. It's not clear what it means when they overrule themselves.
We have time for one final question or comment. Yes.
I just want to preface my question by saying I absolutely think that the type of techniques do constitute a practice of torture. But I was wondering, when you're talking about if it's torture now compared to the learning it in degrading people then, the extent to which contemporary practices of torture and the war on terror may make the kind of techniques that rather tame by comparison to some of the things that the Senate recently have published.
Yeah, Yeah, well, I mean, one of the interesting things which Conor mentioned is that they, in some ways, took the 5 techniques as a blueprint, and then in the torture memorandum, they say, oh, Ireland and the UK says the following things are not torture, so they're okay. And then they ramped it up, and they ramped it way, way up.
Yeah, I mean, sorry, who are you? Jess. Sorry, I didn't see it around the corner there. I think I just avoided in my talk, Jesse, as you will have noticed, because I said the CIA thing seems a lot worse. I think I'm not making the case now that what the British did to this number of people remotely resembles the extraordinary, awful, calculated, universal deployment of vicious acts of generalized torture that the CIA seem to have engaged in. I mean, that is not to defend what went on in the United Kingdom, but I think we're talking about different levels, I think. I don't know much about it. I'm relying on David and John Cassidy and so on. But they certainly drew inspiration from this. And it's a bit analogous to the current problem we've got with the European Court and Britain. Britain has this ridiculous kind of antagonism to the European Court of Human Rights, which is then used by other places to justify their bad faith rejections of that court. I think, and so the content of why Britain has that rejectionist position is lost in the deployment of the same position to cover far worse wrongdoings by other barely democratic countries. Similarly here, I think the 5-technique platform was laid out for other countries to be able to use under cover of the British legitimacy, and that's a disaster.
Yes, but I think it's important to make clear that it doesn't change the nature of what they experienced. I mean,
no, absolutely. That's why we have to be cautious. Yeah.
Yeah, as you said in the preface. I mean, it's a line that once you cross, you're over. Sort of like child pornography or something. Like there can be worse kinds. There can be the most horrific. I'm sure there are horrific, unimaginable things. But once it's pornography and it involves a child, it's over that line, and that's. And I think that's where we are with torture. And I think it's clear that the 5 techniques are over that line. And then where we go beyond that is, yeah.
That may be an appropriate moment in which to stop. Thank you all very much. And
Thank you. Thank you, Aileen. Thank you, Chair. Thank you very much, Natasha.